10 minutes past 7, we'll have the weather, and Mike will have all the sport for you coming up a little later on.
Now, the minicab hailing app Uber says it will appeal the latest in a series of court rulings which says its drivers should be entitled to certain rights like the minimum wage, sick pay and paid leave.
The company claims most of its drivers would prefer to be classed as self-employed and says it's prepared to go all the way to the Supreme Court.
Well, we have James Farrar and Yaseen Aslam, who are the two drivers who brought the original tribunal case last year. Good morning.
Good morning.
Also with us is Susanna Kintish, an employment lawyer who's in our London newsroom. Susanna, we'll come to you, gentlemen, in a moment. But Susanna, let's just come to you first. Your assessment of where we are in the case now with Uber.
The most recent decision of the Employment Appeals Tribunal, which we heard yesterday, I think just sings to the same mood music that we've been hearing from the Employment Tribunal decision and the similar cases on this issue. So the City Sprint cases and the Pimlico Plumbers case that's going to the Supreme Court in February next year.
Let's turn to James and Yaseen here. So this was clearly a victory for you yesterday. But Yaseen, just explain to us what your thoughts are, given that we now know that regardless of yesterday's decision, Uber intend to fight on.
Well, looking at what we achieved yesterday, the judge reconfirmed with workers, which we won last year. So as a worker, all we're guaranteed is a basic right, such as making sure that we earn the minimum wage for every hour logged on, and also holiday pay. That's all it is. So it's a worker status where we're still flexible. There's no need to change that flexibility. We're still our own boss, self-employed technically, but we just have basic rights. That's all it gives. That's all it's granting us.
So, what rights did you want? What did you
that's
feel
what it
you
is.
weren't
It's just
getting?
making sure that we've got protection in place to protect us.
So what's this, holiday pay, sick pay?
Well, holiday pay and making
breaks?
sure that we're not being exploited. We have laws in this country, like the national minimum wage, so it's just making sure that every driver and going forward, that the law is being enforced in terms of where we're earning at least a minimum wage for every hour we're working.
This is about interpretation, isn't it, James? About whether you interpret what you do as being self-employed or being employed by Uber. And Uber says that the joy of its employment or employing drivers is that they can be flexible.
Yeah, and Uber tries to create this sort of false choice between fairness and flexibility, and we say there is no choice. In the UK, there's three main categories of employment. There is truly self-employed, where you're in business of your own account, I'm in charge, I can set the price, I can manage my own customers. There's employed, PAYE, gold watch, pension, and then there's this middle category called worker, where you're self-employed, but you're not in business of your own account, you're under the control of another business. And that's a vulnerable place to be if you're a low-income worker. And so we are allowed these rights of minimum wage and holiday pay, and that's about it. Now, Uber is fighting us because, why? They don't want to pay the minimum wage. And it's very important that we have that protection.
Now, one of the points Uber has made consistently, James, throughout this is that they say that many of your colleagues are also Uber drivers are not on your side, that they are content with the arrangements as they are.
Well, that's because Uber offer, they confuse the issue. They say that all the drivers want to be self-employed and that they want to be their own boss. But we're not challenging that at all. So do we. We agree with that. That isn't the choice. So our colleagues can continue to work exactly the same way, except now they have a guarantee that no matter what, they'll earn the minimum wage and they'll get holiday pay. What's not to like?
And just to look forward for us now, you say that the judge found in your favour yesterday, and that's cause for celebration. But it remains an outstanding legal issue as of today, doesn't it? Your status has not changed.
This is quite disappointing because we've been campaigning since 2014. So it's nothing new. So we've been fighting since So by them appealing, it means they're dragging it on longer, and it's not nice for people like myself that have to carry on with this struggle. And going back to your point that you questioned, James, about Uber saying that there's only like a majority of drivers are happy. But as part of IWGB union, we have many Uber drivers that we represent, and a lot of them want this worker status, and there are many claimants that are also part of this case.
Let's talk to Susanna and examine the legal implications of this. So we know that Uber's going to challenge this decision. Is this case, the reason we talk about this case is there is an insinuation, isn't there? This could set a precedent and change the form of employment of workers.
Yeah, I think James is right in his characterisation of the three statuses, if you like. There's genuine employees, there's people who are self-employed, and there's this intermediate category of workers. The workers, I don't think it can be properly characterised as a subcategory of self-employment. I think the real issue is that, look, employment law in this country has been built up on a foundation of protecting those who are exploited and the most vulnerable, and I don't think there's any suggestion that that ought to change. It shouldn't change, and people who really are unequal in the relationship that they have with the entity to whom they're providing services or which is employing them ought to have proper protection. Obviously, the flip side for business is that where there is genuine two-way flexibility, if the signals continue in the way they're going, and obviously we'll get some more definitive guidance, hopefully from the Supreme Court in February, if it continues to go the way it's going, then even where you do have genuine two-way flexibility between an individual and an organisation, if they're found to be workers, then that comes at a cost. You mentioned holiday pay, national minimum wage, sick pay, auto-enrolment for pensions. There's lots of additional costs that comes with that, and that has to be borne somewhere, either by the business, either passing that on to the individual who's contracting with them via a different fee-sharing arrangement, or passed on to the consumer. So I think
okay. So, Susanna, can I just, because we're slightly short of time, James, just on the last thought, away from some of the technicalities, personally for you guys fighting this case, I mean, there must have been times when you wondered, because it's not easy always putting yourself in the front line of these things.
It isn't. You need to be a little bit crazy to take on a $70 billion corporation. We're up against an army of lawyers, PR professionals, political lobbyists. But the law's been on our side, and the IWGB union has become the de facto union for the gig economy. We've got their support. They've been behind us 100% of the way, and we're very fortunate.
I appreciate your time this morning,
Thank you.
James Yaseen and Susanna Kentish. Thank you very much for your time as well.